Testing. Good morning. This is a test of the audio system. Thank you for taking your time to come out today.
Good morning again. All right. Welcome. A few opening announcements before we get started. My name is Aaron Nash, Clerk of the Court. You are here. Thank you. I think I heard applause. It probably wasn't for me, but that's okay. You are here part of the court's oral arguments on the road program. The court goes to the 2 Arizona law schools every year and 2 other locations around the state because it is a state Supreme Court, so they like to move around.
Okay, that's our first lesson. We have to push the button for the microphone. Good morning and welcome. Before we call the case, I just wanted, just in case council leave before after the second argument, to thank you, all council, for coming to ASU and coming out of our usual environment to have oral argument today. The court thinks, of course, it's so important for people in the community to see oral arguments, and our community includes, of course, our future lawyers. And we're happy to see all of you here, and so nicely dressed, just like our usual components in our courtroom, nicely dressed up for the argument. Thank you for that courtesy and respect. So first first case of the day is Doe et al. Versus the Corporation et al. It's our number CV-25-0213. A couple of things before we get started. First, each side, as you know, you have 20 minutes time there at the podium for you. You may keep whichever time you like for your rebuttal, but you have to keep your time yourself. And with that, please begin.
Push the button, please.
Okay. The Arizona reporting statute avoids the First Amendment problems by creating an exception for confidential communications and confessions to clergy and deferring to the judgments of the religious authorities. The decision below creates all manner of First Amendment problems by misconstruing the statute and remanding for these religious questions to be decided before a secular jury. The abuse underlying this case is beyond awful, but the legislature understood the need for an exception even when church members confess to the worst acts that transgress both secular law and church teaching. In ignoring that legislative judgment, the Court of Appeals conflated the reporting statute and the priest-penitent privilege and opened the door for discrimination among sects based on such things and vagaries as whether a spouse can participate in a confession or the purposes underlying a church's excommunication process. Fortunately, the path for avoiding the First Amendment thicket is clear. This court need only reaffirm the plain text of the reporting statute, which, as written, accommodates religion and avoids First Amendment difficulties.
Mr. Clement, may I interrupt you and ask at this point, what I understand the argument is we have to church to decide whether ecclesiastes is and that type of thing. Where does assessing credibility come into the mix? Because I can certainly imagine, I'm not saying in this case, but in other cases, that perhaps the clergy member is not telling the truth. Perhaps it really wasn't a communication that was taken that way. So where in your paradigm does it fit to allow the court to assess credibility?
So I'm not sure there's a role to assess credibility as such. I don't think it would violate the First Amendment for courts to interpret the reporting statute with a sincerity requirement, which is a little different from credibility. So, if you had sort of, a church of non-disclosure, and they treated everything that ever happened in the church as confidential, and specifically things that had to do with, seemingly, very beneficial church if you wanted to keep things from law enforcement. I think that would be a situation where the courts, consistent with both the First Amendment and the statute as written, could say that's not a sincere belief. But I think it's
I'll
long.
ask you a question about before we go any further down that road, because we've had two terms introduced so far. One being credibility, take it of the clergy member, and then general sincerity of belief. I'm going to focus it a little bit more on the particular statute here, and I think you've accurately described it as an exemption from an otherwise mandatory reporter requirement. To what degree, and this may get to the heart of what the question is here, to what degree is there a role for judicial inquiry that doesn't run afoul of the First Amendment, but allows a court to determine, was there in fact a confidential communication? Or was it a confession? Or is the clergy member's determination that it's reasonable and necessary really reasonable and necessary?
So, there's a lot of subparts to that question, but let me try to be as responsive as I can. I think, there is some role for the judiciary to determine whether, there was a confession or a confidential communication in the first place. I think that would be an issue that you would give some deference to the clergy on those questions, but I think there's some judicial role there. Where I think the statute is most particular, though, is once you have a confession or a confidential communication, on the question of whether it is reasonable and necessary within the concept of the religion to keep that from disclosure. I read the statute as really having a rule of essentially complete deference. I think that word determines is not that different from a word like deems, and it really doesn't create a judicial role for sort of second guessing that particular determination.
Okay. So my concern with that then is it seems to read the statute as one of immunity and not exemption or exception. And let me be a little bit more detailed on that. If someone makes a determination they think it's reasonable and necessary within the concepts of the religion, reading from the statute, isn't there room, here's the question, isn't there still room though to inquire, well, what are the concepts you're applying here? Now, once you hear that as a judicial officer, you may be foreclosed from further inquiry, but just as in the first step, shouldn't the person claiming the exemption have to come forward with something to show this is why it was reasonable and necessary?
So I don't see that sort of kind of first production requirement in the statute as written, but I'm not sure, if you want to read it into the statute, I'm not sure that alone.
Well, I'm not, be clear, I'm not reading anything into it. It says what it says. But if you're going to claim that you fall within the exemption, aren't we in a similar situation of any other particular statute involving a privilege or an exception that if you want to claim it, you've got to demonstrate that you fit within it?
Well, sure. You have to assert that, the defense to the reporting statute. I do want to be careful about the word privilege because I don't.
Well, and I mentioned that as a class of statutes in which if you're going to assert that you fall within the provisions of a statute, I don't want to conflate the two here. If you're going to say this statute applies to me, I think in the first instance, you have to demonstrate that you do in fact fall within the statute.
I think you have to assert that you fall within the exception. I don't have any issue with that. And I didn't mean to be pedantic, but I do think at the heart of one of the Court of Appeals errors here is treating this reporting statute as if it were a privilege or conflating it with the priest penitent privilege. And if I could, I would like to elaborate on why that's such a fundamental mistake, because this is very different. The reporting statute and the obligations it imposes on clergy is very different from the priest penitent privilege. And most particularly, the reporting obligation is a self-executing obligation that is backed with felony punishment if the clergy makes the wrong call. And that's very different from the priest penitent privilege, where if a priest thinks that there is the privilege available, that's ultimately going to be adjudicated in the litigation, and they won't be forced to testify unless a judicial officer is determined, no, the privilege doesn't apply here. But because this statute is self-executing and a felony privilege, there I did it, a felony backed by, yeah, exactly, backed by felony punishment, I think you have to be sensitive to the fact that in real time, there has to be deference to the determination of the clergy. And in particular, that's why I think it's fundamentally wrong to think that if years later the penitent confesses or discloses this information to a third party, that somehow could retroactively activate the reporting privilege, because the reporting requirement, because the reporting requirement based on the text of the statute is a requirement to report immediately. So the clergy in that situation really has to decide in real time, am I obligated to report this? And I would also emphasize that this is an exception with an exception. And so there is this last clause in the reporting obligation that says there's a further exception for personal observation of the minor. And that's another place where, with all respect, the Court of Appeals got tripped up, because it thought the confession before the penitent and his spouse was somehow maybe not within the coverage of the exception, because the bishop of the church was in a position to personally observe the penitent's spouse.
Well, let me ask you a quick.
Sorry. Oh, I just wanted to follow up back on your answer and then back on my original question about credibility, because I really want to see how this statute is to operate even beyond the current situation that we have. So say in this case, you have the clergy members who have said that, yes, under my, using the language of the statute, that determine it's reasonable and necessary the concepts of the religion to keep this confidential so it doesn't trigger the reporting requirement. If there is in the litigation maybe another clergy member who comes forward to say, you know, that's completely wrong. It is not within the concepts of this religion to keep this kind of thing confidential. Now that kind of sets up what I had originally imagined to be some type of credibility determination. In your view, is resolving that determination hands-off because of the First Amendment?
Absolutely hands off. I mean, to me, that's sort of the nightmare scenario, that you would have kind of a battle of expert witnesses about Roman Catholic doctrine or the Church of Latter-day Saints doctrine. I mean, you know, and it is in the nature of some of the most established religions that you can find adherents to that religion who have differing views on church doctrine. And of course, that's within a hierarchical religion. But in a religion that's less hierarchical, I mean, you may have sort of different sort of churches within the loose organizational structure that have fundamentally different views on a question. And I think that it's very important for the secular courts to stay out of those disputes. And I think one of the reasons is important because you don't fall into the trap of kind of inadvertently discriminating among and between religions. Because, you know, in some of these questions, it seems a little easier when you have a hierarchical church, because if you had one priest in the Catholic Church that had a very idiosyncratic view of something, you might say, you know, tell it to the Pope. That's just wrong. But in a less hierarchical church, I think you'd have to give greater deference to the views of the clergy in that particular case. And I think you can kind of head off that potential for discrimination among the religions by just taking the hands-off approach.
Is there any, one last follow-up? I just might, and I'll be done with that, my questions. Is there anything in the statute which prevents a scenario that I think that is somewhat concerning, that simply you have a clergy member who uses this as a, oh, I didn't report, I should have reported, well, I'm just going to say that that's what, that was my reasonable determination of what was required by my religion. So it seems a little bit of a free pass. And is there anything, and maybe that's just what it is there anything that prevents that, in that scenario under the, as you interpret the statute?
So I think other than the sincerity backstop, I don't think there anything is. I think that's the price that essentially we have to pay for having this reporting statute that, you know, absolutely has a number of provisions that accommodate religion, avoid entanglement, protect religious autonomy. And sure, there are going to be some hard cases anytime you do that. I mean, there's going to be some case where, you know, it's a religion the judge has never heard of. The judge might be very, very skeptical of the claim, but nonetheless, I think in those cases, other than the sincerity backstop, there's deference that needs to take place.
Counsel, you seem to draw a distinction between more hierarchical churches and not, and I'm just trying to figure out, so what is the effect when the dispute as to church doctrine arises within the church, the smaller, less hierarchical church? So not talking about two different churches within under one larger one, but within the church itself, let's say two priests in the same parish.
Right, and I'm desperately trying to avoid distinguishing between the hierarchical churches and the non-hierarchical churches. And I would say that with that non-hierarchical, maybe it's just one church, and you know, there's two priests, and that's it. And they disagree. I think you still have to defer to the judgment of the one on whom the state is trying to impose the reporting obligation.
No doubt we have to interpret this statute in conformity with the free exercise clause. Any establishment clause concerns here. Essentially, it seems like the religion is determining the criminal exposure and civil exposure as well. There's some language in the Presbyterian Church decision on that. It strikes me as a little bit like Curious Joel in terms of empowering the church in this way. Can you speak to that?
Sure, I'd be happy to. I mean, I think the Presbyterian Church is from an era where the Supreme Court maybe, kind of put state governments between a rock and a hard place with respect to the Establishment Clause and the Free Exercise Clause. I think the Supreme Court in more recent cases has made it a little easier. And I do think that there's a pretty substantial room for states to accommodate free exercise values without running afoul of the Establishment Clause. One of my favorite lines from Supreme Court decisions is from Zorich against Clausen, where the court said that when the legislature accommodates religion, it follows the best of our traditions. And I think the Arizona legislature here really has followed the best of our traditions by building in these accommodations for free exercise and religious autonomy. And, it's an interesting exercise, I think, to think, well, what if the state legislature had imposed this reporting obligation squarely on clergy and created no exception at all for the confessional? And I think in that instance, the Arizona courts would be in the awkward position of having to carve out exceptions in order to make the statute consistent with the First Amendment and the Free Exercise Clause. I feel like the Arizona legislature has, in a sense, done the courts a favor by doing the accommodation themselves. And I think where the Court of Appeals sort of got tripped up in this case is it really complicated what the legislature had done and reintroduced a lot of these First Amendment problems. And as I've alluded to, sending the issue of whether this is really confidential back for a secular jury, that seems a mistake. Misreading the statute by not focusing on the fact that it talks about personal observation of a minor was another mistake, and essentially second-guessing the church's view of whether the people who participate in the excommunication process are clergy. I think all of those were mistakes that the statute as written really avoids. And with that, if the court doesn't have any other immediate questions, I'd reserve the rest of my time for rebuttal.
Thank you.
May it please the court, John Trebone with co-counsel Lynn Cadigan on behalf of the Doe minor children. We just heard a bunch of discussion about the First Amendment. I want to put this case in perspective with a couple big picture points. Number one, you didn't see in their brief and you didn't hear it today, the Smith case, Division of Labor, Oregon versus Smith. That is the controlling case on whether or not a statute is constitutional and proper. Our statute, and I just don't, not my opinion, aside to Colombo, the New York University Law Review article and others, our statute's absolutely constitutional. So let me give you a thought. If our statute passes Smith, how are the rest of these First Amendment cases relevant? How are they relevant at all? I suggest to you they aren't. Because if this statute is constitutional and proper, we don't use First Amendment cases to try to misconstrue or rewrite the statute. We don't use them as a leverage against the statute. So once the statute passes Smith, there is no First Amendment issue. Now there is obviously, I believe in Roman numeral 3 of the court's opinion, as you know, that's moot, and I don't think anyone seems to argue any differently. The other big picture I want to get to right away, is what happens if they win? What happens if the church wins in this case? What would that mean? Because the answer is documented history. We know the answer to that question. It's called Nunez versus Watchtower. In Nunez versus Watchtower, a very disturbing case, but 3 children come in. It's a Jehovah's Witness case. 3 children come in and talk about abuse. The person's disfellowed, reinstated, disfellowed, and reinstated. Finally, they sue when they become adults, $4 million in compensatory damages, $31 million in punitive damages. It's overturned. It's a Montana 2020 case. And why? Good reason. The Montana statute says what they want this statute to say. You should compare them. The Montana statute expressly says what is confidential is determined by canon law and religious practice. So canon law, religious doctrine, and religious practices in Montana determines whether or not it's confidential. Look at our statute. And that's the result they're looking for, exactly the same thing. How would we get Arizona's statute to line up with Montana's statute unless we substantially rewrite it? I suggest to you that's impossible. And there's a State versus Bragg, a Michigan appeals opinion that does the same thing. So in my research, there's 2 cases throughout the country that give the church exactly what they want in this case. And the statutes are completely different. It's night and day. And this whole thing about we're conflating the privilege with the exemption. What's the common denominator? Confidential communication. It has to be a confidential communication.
Well, could you address, though, a bit what I think of as the crux of the language that I'm not sure is in the Montana statute or others, is that it says that this is supposed to put somebody on notice of what their reporting requirements are. So it tells the clergy, in this case, if it determines that it is reasonable and necessary, if the clergy member determines, it doesn't say if the canonical law of the particular religion requires this. It puts the emphasis on if the clergy or a priest or whomever determines. So how do you give me your best argument about why that allows us to go beyond simply, well, they made the determination and we can't really question whether it was a accurate or good determination?
Well, absolutely. There's a 2-step process under the statute. You're talking about the second step. I submit to you, the first step is confidentiality. So it's a secular statute. It's determined by the courts, not by the religion. And I may disagree with Paul on that one because Presbyterian Church versus Blue Hall expressly says you cannot delegate to the church the power to construe or apply a state statute. Unequivocally wrong. And we have several other cases in our brief that follow that. But if you look at the statute, if you look at our exhibit, they moved confidentiality to the bottom. That's where it's only reasonable and necessary for them to determine if it's confidential. If you shift the word confidential, and that will twist the meaning of the statute. So I believe it's the shift and twist argument. But it's the court's obligation to determine confidentiality, and in fact, it wasn't.
Council, may I ask you a question about that? In determining confidentiality, the way I read the statute, that also is determined within the confines of applicable church doctrine. So it's not just a generic confidential communication determination that there may very well be. This is why I asked opposing counsel the question about how far can a court go in initially making a determination as to whether or not this exemption applies. So, I might look at a confidential communication just as 2 people off in a corner, even in a crowded room. But a particular faith might require something more for a confidential communication. It might require meeting within the bishop's office with nobody else there. So those 2 things could be very different. And the latter example that I gave you, more applicable to this case, is going to be something where we have to take into account, because ultimately a determination is going to be made by that clergy member within the concepts of the religion. So I'm not quite sure it's as broad as you're arguing. Where am I wrong?
Both. There's 2 confidentiality determinations in the way you set it up. You're exactly right. There's 2. Number 1, it has to be confidential. In other words, that's a judicial determination, a trier fact determination. Was it a confidential communication? But if the discipline or the course and scope of the religion doesn't require the clergyman to keep it confidential within the concepts of their religion, it doesn't pass the exemption or the privilege either. So it has to be both. But there's certainly a fact-finding confidentiality requirement under the statute. And then, yes, if the church in their own doctrine don't consider it confidential either, then it's not going to be a confidential communication. So it's a dual requirement. Within the course and scope of the religion, they must keep it confidential. That has to be part of their doctrine, but it doesn't take away from the fact finding of the trial court to determine whether it's confidential in fact.
Well,
In fact,
let
I'd
me
say,
ask you a follow-up question about that, counsel, because if we're being mindful of the free exercise clause, and there's a particular faith that in the exercise of their redemptive process, they determine that a setting is confidential, and we want to apply the statutes, I think you're intimating, don't we run into a free exercise problem then? That you didn't do it the way we thought you should, therefore you're not going to be able to avail yourselves of this exemption?
well, not if we do, if my argument is correct and it's a dual requirement, it certainly doesn't infringe on free exercise for the court to determine whether it's a confidential communication. I mean, Justice Montgomery, I think you did the same thing in Ray mental health care case, a very recent case with the behavioral health privilege. You had two requirements in that case of confidentiality, that it had to be understood to be confidential and it had to be treated as confidential. Why wouldn't those same elements require here? It's a state
Well, the easy way to
statute.
distinguish that is that the First Amendment didn't apply in that context. So there's another layer here we have to keep into account. And I know you want us to pay attention to Smith, and we don't read tea leaves on this court for what the federal Supreme Court might do. But I don't know how many more miles Smith gets to run. That may be on its last legs.
Well, obviously, I don't think you're going to overrule Smith.
Well, that's not our role.
And look at this statute. I mean, just not me. Look at Colombo or any other law review. If the statute is neutral and generally applicable, it's honored. And as you wrote in that recent decision, confidentiality is the heart of all privileges. And in the exemption here, by the way, what is the exemption? Mr. Clement's saying, well, it isn't, it's apples and oranges. But 3620 is a partial abrogation of the privilege.
Well, counsel, let me clarify this point too, because I was a bit confused in your briefing and going back and forth from the privilege to the exception. The privilege is held by the penitent, and the privilege relates to testimony. We're in a mandatory reporting statute that requires reporting by the clergy member. It's got nothing to do with testimony. So when we try to treat those two things together, I think we're missing who the focus is of the inquiry. So getting to the mandatory reporter statute here, help me understand how the privilege analysis is applicable to the determination here.
Well, the core commonality is confidentiality. So that is the core of both of them. But it's a partial abrogation. In other words, even if there's a privilege communication, under this statute, they still can report it. So that what the legislature did, obviously this is a reporting statute, not a privilege statute. Of course, we agree. But what the legislature did is they said, hey, even if you have a privileged communication, the clergy may report it anyway. And then their testimony is discussed in L and not in A. But nevertheless, this is a partial abrogation saying, hey, we're going to partially abrogate the privilege. And for the reporting statute, we're going to say they can report anyway.
I'd like to go back. Oh, the Chief Justice asked a question earlier. You were talking about there's two parts to this, the confidentiality part and then the second part that the Chief Justice referred to. And it strikes me, as the Chief mentioned earlier, the language in the statute, just the statute says, if the priest determines that it is reasonable and necessary within the concepts of the religion. And it strikes me that the word reasonable, the placement of the word reasonable there is meaningful. In other words, the legislature did not say something to the effect of if the priest reasonably determines that it is necessary within the concepts of the religion. So I'd like to have you focus on that second part that you were referring to earlier, and it goes back to the Chief's question earlier.
Well, actually, on that part, there's two parts that I'm going to agree with Mr. Clement. And number one is, if the church determines, if you meet the first element, you're in step one, and it's the confidential communication. That's a trier of fact issue every day. But if you meet that element and you're going to the second part of the statute, yes, is a clergy member authorized in their relation to receive the confession or the communication? And are they entrusted to keep it confidential within the confines of their religion as reasonable and necessary? That is not a secular determination. That is a religious determination. So I agree that that's something that the church determines solely and not the courts. But that would only be the second step. And the other thing I agree on, whether or not the communication is privileged occurs at the time of the communication. No retroactive ad hoc determination. We agree with that as well. And so I think maybe my briefing might have been a little confusing on that, so let me clarify that. In the second confession, when Lisa Adams comes in and Paul is told to confess to her, obviously there's no confidentiality. At least, I mean, there's three people part of that communication. One of them is gone. The other two people didn't consider it.
How is that obvious?
Yes.
It wasn't obvious to
Not
the court in
obvious to at least
Archibald.
two of us.
Well, it was a summary judgment. Why do I think it's obvious? Of course, Lisa, after being prepped, said she didn't consider it confidential. So there's one person. And the second person wrote a declaration much later saying, I considered it confidential. But what did he tell Special Agent Edwards in 2018 before his deposition? Well, in fact, Edwards leads him, gives him a leading question. Well, obviously, you thought you couldn't report because of church doctrine. No, that's not it at all. Church doctrine had nothing to do with it. It was Arizona law that required me to keep it confidential, not church doctrine at all.
Well, regardless of that, the exemption applies only to communications or confessions and not to personal observations the member of the clergy may have otherwise made of the minor. And I think Mr. Clement made that argument that that's how the Court of Appeals below was tripped up on that. This wasn't an observation made of the minor. I think your argument is observation of the confession or the communication, but doesn't the statute require that it have to be an observation made of the minor?
Well, absolutely. So that was just a poor choice of words. I don't know why the Court of Appeals did that. They could have used the word overheard instead. But what the court was trying to say, and it didn't say it in the best way, is that it wasn't a confidential confession. It wasn't confidential, but the observation word it was a poor choice of words, I think, in that situation. But
well, we're left with their words.
Well, you can change it. But the point is, it was never confidential in the first instance. That's what Bishop Herod admitted to Special Agent Edwards. That's what Lisa Adams said in her deposition, and Paul is gone. So how could we lose that issue of fact on summary judgment? How is that possible? That is a determination, a judicial determination to be made by a trier of fact.
Well, can you, one thing about the statute that I notice is that, and you have said several times to talk about it has to be confidential, a privilege, an exemption of privilege, but they don't use privilege. They talk about confidential, as you say, communication or confession. And our privilege statute uses just confession. I was noted by that the clergyman or priest, should also be clergywoman, without consent of the person making a confession as to any confession. And this statute is a little broader. It struck me that they use communication, which of course we always say that they must have meant something more than simply confession if they used another word. And there wasn't much focus on that, but I focused on it and I wondered what your take is. So I could see here, for example, that a priest or a clergyman could consider, I'm going to communicate with this family. I'm going to consider the whole thing confidential and trying to counsel people, and I want to keep that confidential. So it doesn't have to be a confession, and you don't look into waiver in the presence of third person. I could see that occurring. So could you comment on that interpretation?
Absolutely. It's true that it looks like it's the exception seems to be broader than the privilege in theory, but not in practice. Why is that? Because the courts have been so accommodating to religions over time that confession is, if you look even at the proposed federal rule of evidence 506 that was approved by the Supreme Court and not by Congress. It uses the same language. In fact, it appears to me that whoever wrote this statute at the legislature took the language that mirrors proposed rule 506. So it's been a long time since only confession, an admission of sin with the desire for repentance. That used to be the definition of a confession. It isn't anymore, and it hasn't been for a long time. So the more modern exemption that was written in 1982, it's more modern than the privilege statutes. But the truth is they're exactly the same in that respect. Look at Archibald. I mean, that was more than a confession as well. That's not a reporting case. That's only a privilege case, right? And Archibald, unless you overrule it and construe the statute to be more limited than the exemption, Archibald did a lot more than confess sins. It was pastoral counseling as well. And the court, Judge Fidel, considered that to be confidential. So in practice, the word confession, the word confession is being given much wider range. The clergy penitent privilege is a misnomer now too, isn't it? Because it's obviously a congregational clergy privilege as well now. Anyone can go to the priest. They don't have to be a penitent necessarily to receive both the privilege and the exemption.
What about Paul's statement before the disciplinary council? Is that a confidential statement?
Thank you. I believe, number one, it's funny if you look at the language in their briefs, and it was hinted at before. Of course, it's a sword and a shield argument here. We don't know what Paul said, but yet they leak. Well, here's what what we want you to know about what he said. If it was really privileged, we shouldn't know it at all. But in any event, I don't believe Paul confessed to molesting the DOE children in front of the disciplinary council anyway. I think he confessed to having sex with his mother. At least that was the letter that Lisa Adams said she read when she got it from the church. But nevertheless, to answer your question, I believe the disciplinary council under case law is probably privileged if everyone was a clergy member and there was a common understanding of confidentiality. Then the clergy members could receive that information in a privileged manner. But what do we know that Bishop Mozzie said in this case? Because if you look at their handbook, it lays out exactly who should be in it. We know there's 12 high priests, there's a secretary, there's a stake president, 15 people, whatever it is. Yes, I think theoretically that can be privileged if it was all confidential, but there was one person in this particular case who wasn't authorized to be there. And who was it? Lisa Adams. Bishop Mozzie said, hey, we let her in. Was she there? Yes. She came in and kind of silently listened. Well, that's a problem. And you know why it's a problem?
Mr. Turbin, you're past your time. Could you just give me just one wrap-up sentence?
It's a problem not only because she wasn't authorized to be there, she's a mandatory reporter. So my last parting shot is, I think this court should be careful to say things are exempted or privileged if they're given in the face of mandatory reporters. That should be a very important separate consideration. Thank you.
Thank you. Mr. Clement.
Mr. Clement, I'd like to return you to confidentiality. I think you said that there may be something for a jury to determine there, whether it is confidential. And we recently had an argument where in a case involving a clergy member who was also a friend receiving a confession, and whether that it was confidential partially or completely. So what is the role of the jury, if any, and to what extent does church doctrine dictate the result?
So even as to those questions about, is this confidential at all? I think there's some judicial role, but I think there would be a lot of deference to the church doctrine in a way that would have to be sensitive to the First Amendment sort of landmines that are all around here. And one illustration of that is, it may, to somebody that's sort of got a Catholic background, it may seem weird to have a spouse in the confessional, but that's just routine in other religions. And you have to be very careful about sending the confidentiality question to a jury without giving great deference to the teaching of the particular religion at issue and their views of it. And I think in most of these cases, you wouldn't ever have the issue actually going to the jury. Now, if I could make just a few other points in rebuttal, my friend emphasized the Smith case. I think it may well be on its last legs, but it has nothing to do with this case. This privilege, or rather reporting statute, is expressly carves out treatment, differential treatment for clergy. It's not a neutral law of general applicability. Smith has nothing to do with it. Now, of course, one of the reasons that a lot of people think Smith is on its last legs is because if this really were a neutral law of general applicability, there would still be a lot of First Amendment questions under the church autonomy doctrine. And the church autonomy doctrine is this interesting thing where the courts are treating religion specially and accommodating it, but they still look askance at a law that's not neutral for general applicability. Nothing to do with this case. I do want to sharpen my answer to your question earlier, Justice Bullock, about whether there's any Curious Joel or Grendel's Den problem lurking here. There isn't. There's a fundamental difference between deference to religious judgments, which in many cases the First Amendment requires, and delegation of government authority, like you had in a case like Grendel's Den. That's just not an issue here at all. The last thing I want to say before I sit down is on this question of, was this really treated as confidential? Just because the penitent's spouse was in the process in the bishop's office? The answer is, of course, it was still confidential. The Archibald case essentially already holds that in the Court of Appeals, but it's even more emphatic in this case because one of the facts that I think really speaks to the confidentiality here is the fact that the bishop told both the penitent and his spouse that they should report this to the authorities. He wouldn't have said that if he thought he was in a position to report it to the authorities. So in real time, the bishop understood that this was confidential under church doctrine. Last thing, I'll say two last things. One, just on your opening question, Justice Bullock, I also do think that there is a requirement in this statute that the confession be in that person's role as a member of the clergy. So I do think, if somebody tells a clergy something on the golf course, that might not be covered by this, and that's another fact question. The last thing I'll say is the relief we would ask you to order is to affirm the summary judgment disposition of the Superior Court, so this case is over and there's no ongoing threat to religious autonomy. Thank you, Your Honors.
Okay, thank you, Mr. Clement. Thanks to both counsel, all counsel, really, for your briefing and for your argument here today. It was, and for those of you in the audience, this was excellent argument on both sides. We will take the matter under advisement and issue an opinion in due course. Before you leave, thank you again. You're welcome to stay for the next argument, very related, or not. If you do leave, just so you know that after all the arguments are done, we plan to stay and answer questions from the audience. You're welcome to answer any questions that come your way. We will not be taking questions about the case, either of the cases today, so you can be assured of that. So we will stay on the bench and allow the next set of litigants to come forward. You have real lights in here to get your picture. Yes. Always a challenge.